Good afternoon, everyone. Thank you for joining us. I'm going to give everyone a couple minutes to file into our room here, and then we will begin our labor law update shortly.
Good afternoon, everybody.
Yes, I hope you've all had a great start to your day. And it's about to get even better because you get labor law updates now with Mary and Jessica, sponsored by the Central Regional Valley Regional Hotline, excuse me. Before we begin today's webinar, I'd like to go over a few housekeeping details with you. The handouts for this presentation were attached with the login invitation that was emailed out yesterday. If you did not receive these handouts, please let me know in the chat box and I will make sure you get a copy. Throughout the presentation, your audio will be muted, which means you can hear us, but we can't hear you and you can't hear each other. You can type questions into the question box at any time and we will address those as we go. Because your feedback is very important to us, please complete the survey that will pop up at the end of the webinar. It shouldn't take more than a minute to complete, and it provides you with another opportunity to ask questions, and it provides us with valuable feedback that we use to improve our webinars. Your speakers today are Jessica Hawthorne and Mary Bradford, and with that, I'm going to pass it over to you, Jessica.
Thank you so much, Stephanie. Good morning, everybody. I am Jessica Hawthorne. I will be lurking in the background today while Ms. Mary Bradford regales you with leave laws in California. So if you go to the Q&A box, it's the box with two little speaker boxes rather than one. The chat box is for Stephanie if you have technical issues or if you want the slide deck. But go to the Q&A box because that's where I'll be living today to answer all of your questions as we go along. And if there's a question that comes up that seems relevant to our whole audience, I will politely interrupt Mary and question and answer live so everybody gets the benefit of that question. But other than that, I will hand it off to Mary.
Great. Thank you, Jessica. And hi, everyone. So glad that you're able to join us today. We have 1 hour together to talk about every single leave law in detail in California. And I would love to tell you that we could actually do it in an hour, but we can't do it in an hour. But we are going to give you a really nice overview of all of the leave laws that you are probably dealing with for your business. So first of all, just really want to thank all the Central Valley counties that have come together to provide a hotline to you. The slide I have up now lists the individual hotline numbers for each of the counties. So I know we have a lot of people on today's call. You are calling in from all different counties. So please make sure you use the hotline number that is associated with your specific county. I'll give you just a second to jot those down. I also have the slide at the very end, so I'll remind everybody about your numbers. But the complimentary HR hotline is being provided to you free of charge. And so you are able to give us a call at CEA Monday through Friday, 8 to 5, and ask us any type of HR related questions you might have. So if it's on leave of absence, there's some follow-up questions you have after today. If you have a question about overtime or other wage and hour issues, how to handle remote workers, give us a call. We are very happy to help you. We've been working with all of your counties for several years, and we know a lot of the challenges that you're facing. So we're happy to try to make your life a little easier, which is really what our goal is here at CEA. So CEA is the California Employers Association, and our job is to try to make your life a little easier. We have been dealing with HR in California since the 1940s. That's when CEA was founded. And we want to help you out when you've got those HR issues, or maybe you need some on-site training, or maybe you need something a little more involved and maybe need somebody to come on site and help you with something. That's our job, and that's what we can do for you. So feel free, you can give us a call at any time. Again, you're going to want to use that hotline number. You will see that we have our main number on all of the slides, but please do use the hotline that's associated with the county where you are located. Now, I do want to remind everyone that CEA is not a law firm. So when we're talking today, I won't be giving you legal advice. I'll just be providing you with as much information as I can about the guidelines when it comes to leaves of absence. So we do recommend you always do consult with an attorney if you ever do have a matter of legal significance. All right, here is our training agenda. We have a lot to cover today. We're going to talk about employee headcounts and why that matters when it comes to leave of absences. We're going to talk about some of the eligibility requirements. In California, we have over 20 different leave laws And there are all different requirements for those leave laws based on headcount, based on how long the employee has worked for you, how many hours they have worked for you. So we're going to go over all of those today. We're going to talk about employer as well as employee rights and protections, and then that good old paperwork process. We are California, which means we love our paperwork. So I'm going to tell you what you need to do for that. Let's talk a little bit about headcount. And when you're thinking about headcount and these laws, because I'm going to break it down based on headcount, you have to think, well, does this apply to me? Does this include my part-time employees? What about my employees who are out on a leave of absence? Well, let me tell you, when it comes to counting headcounts, everybody who is on your payroll counts. So that's full-time and part-time. That could be an on-call or even a temporary person you might have working for you for a couple of months. If they are located in an office, if they are remote, spread out across the United States or anywhere in the universe, hourly as well as salaried employees count. And as I mentioned before, people out on leave. So when it comes to determining your headcount number, it is your total number of employees on your payroll in California, as well as any other state. So keep that in mind. Now, when we talk about the leaves, your employees may not be eligible for every leave, even though you might be an eligible employer. So we'll talk about that specifically when we get to CFRA and FEMLA. But keep in mind, when you're trying to determine your headcount, you do want to include everybody who is on your payroll. So let's start out with the easy stuff. And we were going to talk about leave laws that apply to all employers. So regardless of how many employees you have, you want to make sure that you're providing these leaves to your employees. So paid sick leave. You're probably pretty familiar with paid sick leave. It's been around since 2015. And just as kind of a little reminder, paid sick leave is for all of your employees, and that gives them up to 3 days or 24 hours of paid time off where they can take care of their own health needs or the health needs of their families. And really, this was put in place to protect employees when they had a situation come up. And this is pre-COVID, but this is, when people would just get the flu or when a family member would get the flu. So it gave them a little bit of protection when they needed to take some time off. There are two different options when it comes to paid sick leave. You can either offer your employees a lump sum where you just dump 24 hours into a paid sick leave bucket for them, or there's also the accrual option where an employee can accrue 1 hour of paid sick leave for every 30 hours that they work. Now, keep in mind with paid sick leave, this is not seen as a wage, and so therefore it is not paid out at termination of employment. So when someone leaves, you don't have to pay out any accrued and unused paid sick leave. You can also have your employees wait until their 90th day of employment before they are able to utilize their accrued or granted paid sick leave benefits. But keep in mind, several cities have their own paid sick leave requirements. I'm going to show you that's going to be our next slide. But I know you might be based in the Central Valley, which pretty much follows the state of California general guidelines. But if you do have employees in other cities or counties, you're going to want to take a look into their requirements. And we do have a really nice summary of all of those paid sick leave requirements. You can access that at our website, employers.org, under the HR form section. Now, a big change and a little labor law update preview for you for 2023 is they have now added the term designated person to a covered reason why an employee can take some time off. Now, the definition of a designated person, you're actually going to see that again when it comes to CFRA, but it means a person identified by the employee at the time the employee requests paid sick days. So that's a pretty broad definition, right? But really why they put this in place was that so individuals who maybe don't have family that they are related to by blood, maybe they don't have anyone in the area, but they have somebody that they care for or that cares for them, that can be their designated person. So they are able to designate somebody besides the usual covered protected reason, which would be spouse, registered domestic parent, partner, parent or grandchild, grandparent. There's a lot of different covered reasons, but this new designated person will be new for 2023, which means you're going to need to make a policy update to your paid sick leave policy to add that as a covered reason. Now, as I mentioned, we have a lot of local ordinances that come into play in California. that might require more than 3 days or 24 hours per year, but these are really focused around some of our bigger areas. LA, San Diego have a couple, as well as many in the Bay Area as well, San Francisco, Emeryville. So this is where you have to remember, you need to make sure you know where your employees are working. So if you have a more remote workforce now, and maybe everyone is not based in the Fresno area, you've got people scattered around California, you want to double check the cities where they work so you can make sure if there is a greater paid sick leave benefit for that employee who works in that city, that's the paid sick leave benefit you want to follow. So remember, it's not where your specific office is located, it's where that employee does their work. Those are the benefits that they're going to be entitled to. Now, another reminder of still COVID is all in our lives is we still have what's known as exclusion pay, and this applies to all employers as well. So this is a benefit that you need to provide your employees if they are home quarantining following a work-related COVID exposure. So this is specifically when an employee is exposed at work and they need to go home because they are waiting for a test, they are symptomatic, any of those things that are going on. Now, you as an employer need to make sure you're maintaining their benefits, their seniority, and their pay while they are home quarantining, waiting to get a test result for this. Now, this is an option for you if they are working from home, that you can have them continue to work. So if you're able to issue them a laptop, if they're able to log into the system from home, if they can take calls from home, whatever it is, while you're paying them this exclusion pay, they can continue to work for you. Now, when it comes to worker compensation, there is not actually a worker compensation leave. There's nothing that's defined as that. But there is time off for an employee when they do incur a work-related injury or illness. There is not a specific limit on how much time an employee can take. Maybe it's a couple days, maybe it's a couple of weeks. So there's not a specific leave limitation, as you'll see that we have with some of our other leaves. But you can run other leaves concurrently when it comes to workers' comp. For example, CFRA, which is the California Family Rights Act that we'll be talking about in just a moment. If you have 5 or more employees and the employee is eligible for that, then you can run that concurrently. If you're a larger employer and have 50 or more employees and this employee qualifies for FEMLA, then you can run FEMLA at the same time. Now, when it comes to taking time off for worker compensation, you can require the use of vacation or a paid time off plan. Be careful when it comes to requiring an employee to use sick leave, though. We don't advise you ever require an employee to use the mandatory California paid sick leave time that they might have. But if you offer a paid sick leave in addition to the requirement of the paid sick leave, then you could require your employee to use some of those times. Now, what we have to always be careful with when it comes to workers' comp is Labor Code Section 132A, which is worker comp discrimination. So be very cautious about ever retaliating against an employee who is out on workers' comp. We never want to automatically terminate an employee who is out on workers' comp if they get to a permanent and stationary status, or if they've been out for a while and we can't get a hold of them. Be very cautious with that. Always work very closely with your workers' comp carrier and try to track an employee down or get more information if you know they've been to the doctor but you haven't heard from them. And just be cautious before you take any adverse action. Of course, you can always give the hotline a call if you have a workers' comp issue and you'd like to talk it through with someone. Or again, this is an opportunity where you may need to consult counsel before you terminate anybody. Let's talk about some of the other leaves that apply to all employers in California. There's jury duty leave. So of course, we need to give our employees time off if they are called to be on jury duty, or if they are subpoenaed to witness or to be a witness in a trial, testify in a trial. Then crime victims leave. There is time off for an employee who is a victim of crime. Again, we don't retaliate against an individual who needs to take time off for court orders or proceedings. Then there is something known as USERRA, which is military leave. We allow our employees to take time off when they are called up into active duty. They actually have 5 years of protected time when they are called into duty. And then there's also emergency duty leave. As we know in California, when we have earthquakes or wildfires or any of the other things that California has to deal with, sometimes emergency duty personnel are called up, and that could be volunteer firefighters, that could be peace officers, When they are called up, they are also given time off that is protected. So we always make sure we're following all of those leave guidelines, regardless of how many employees you have. So let's transition and talk about when you have 5 or more employees. You used to be mostly safe if you had 5 or more employees, that there weren't too many laws that applied to you. But a couple of years ago, the state made a change and CFRA was brought down to the level of having 5 or more employees. Prior to 2021, it was just if you had 50 or more employees, but they made a change. And now if you have 5 or more employees, you are covered under CFRA, which is the California Family Rights Act. There are a couple things you have to remember. You do want to make sure you have a CFRA poster now that you have 5 or more employees, and you also have a CFRA policy. So if you have an employee handbook, do make sure you've updated it with a CFRA policy that is compliant. Now, I'm going to give you kind of an overview, and then we're going to drill down into these in future slides. But CFRA gives up to 12 weeks, again, unpaid, job protected time off for an eligible employee. It's very similar to FEMLA if you are a larger employer and you've dealt with FEMLA before, which is again for 50 or more employees. But a covered employer may not necessarily have eligible employees. And I'll show you what that means here in just a second. Let's talk about the covered reasons, though, why someone might take time off under CFRA. Very commonly, it's used for baby bonding. So this is a birth of a child, or if somebody is adopting or taking a child into foster care, that's known as baby bonding. They can take CFRA for that. Also, if it's for their own health condition, again, you can run workers' comp concurrently with CFRA, but pregnancy is not included in this, and we're going to talk about pregnancy disability leave in just a moment. If you have a family member who is in the armed forces and they need to take time off, you can take a CFRA for that. And again, family care, caring for a family member with a serious health condition. So let's take a look at an example here, and I'll kind of show you how these leaves can work. So you have an employee, name is Jane. She's used all of her sick and all of her vacation, and she just told you that she needs time off for knee surgery. And then she's going to come back to modified duty. So let's determine, is she going to be eligible? So again, employees can take CFRA if they have a serious health condition, for baby bonding, or to care for a covered family member. So Jane needs knee surgery, and most likely that's going to qualify as a serious health condition. But of course, you can request doctor certification. We always advise, regardless of the type of leave, that you want to make sure you do all of your paperwork, which means the employee needs to provide some paperwork to you, which is a doctor's note stating that they're going to be off from this date to this date. Now, we need to determine if Jane is eligible. So let's take a look at how somebody can be eligible. So first requirement is they have to work at a California site. So again, you're looking at your total employee headcount. Maybe you have 3 employees in Chowchilla and you have 10 employees in Las Vegas. You have total 13 employees, but maybe you don't have the right number of employees for California. But when it comes to CFRA, if they work at a California work site and you have 5 or more employees, this is going to apply to her. Now, they have to have worked for 12 months for the employer, and they have to work at least 1,250 hours in the prior 12-month period. So what do they get with CFRA? They get 12 weeks of unpaid leave, and this is job protection. So that means you're going to return them to their same or virtually identical position. While they're out on leave, their group health benefits are going to continue. They can be eligible for SDI, which is state disability insurance, or paid family leave from the state. But keep in mind, the granting of those benefits is really just between the employee and the state of California. So you would receive notice when they've applied for those, but the granting of those benefits is determined by the state. Now, intermittent leave might need to be used. Maybe somebody needs to take a shorter duration of time for CFRA, but keep in mind, you as an employer can't state that time has to be taken in more than 1 hour increments. So for example, you can't say CFRA can only be taken in 4-hour increments or more. That is not allowed in California. So what are some of those reasons for leave? Well, again, baby bonding, as we mentioned, each parent is eligible for up to 12 weeks of leave. So if both parents work for you, then each parent can get 12 weeks of leave. Now, when it comes to baby bonding, there is a little bit of carve out. You can say for baby bonding, employees need to take it in 2-week increments, except for 2 separate times where it can be less than that. But what a lot of employers have found is it can work better to allow the employee to take it in smaller increments. So for example, maybe they take 2 days off a week and they work for you 3 days a week, as opposed to just taking one big lump sum off. So there is some flexibility with that. Again, the employee's own health condition or to care for a family member. And here is the list of family members that are covered. As you can see, it's quite extensive. So for a child, parent, spouse, registered domestic partner, children of registered domestic partners was added this year. Adult children are also covered, grandparents, grandchildren, siblings, and parent-in-laws. Now for 2023, as I mentioned before, paid sick leave has a new designated person. CFRA has a designated person, but they have a slightly different definition of a designated person. I know, I also wish they made them the same definition, but the CFRA designation is, designated person is defined as any individual related by blood or whose association with the employee is equivalent to a family relationship. So again, somebody can designate that they need to take CFRA time for a designated person. And again, there's the military time off that I had mentioned as well. So what do employees need to do when it comes to requesting these leaves of absence? Well, when it comes to CFRA specifically, they need to provide 30 days advance notice if that's possible. And there aren't magic words that are necessary. So an employee doesn't have to come in and say, I would like to request CFRA, the California Family Rights Act, which very seldom happens. Normally what they come in and they'll say, I need to take time off, or I need that family leave I've heard about. And that's your trigger as an employee, as an employer, that you need to go down the discussion path and find out what leave this individual is entitled to, how much time, and all the paperwork that goes along with it. Now, your employees do need to provide a completed medical certification no less than 15 days after you request it. So again, that's why you want to be as proactive as possible when you learn about a leave to remind the employee that they need to provide you with a medical note. You're going to keep communicating with the employer. The employee needs to stay in touch with you as the employer and let them know if their return to work date has changed, if any of restrictions have changed that their doctor has told them that they need to follow. And then the employee also needs to provide you with a return to work certification. We always advise before you have your employees come back, you get a note from their doctor saying that they can return to work without any restrictions or modifications. And then it's up to the employee to apply for the state disability insurance for those paid family leave benefits. That is not your responsibility as an employer. That is up to the employee. Now, what do you need to do as an employer? Well, this is your gentle reminder to make sure you have an up-to-date employee handbook where you talk about all of the leaves that employees that work for you are entitled to take. So that means you need to have very clear policies. If you have not updated your handbook this year, it certainly needs an update. And as I've told you, we've already got some changes for 2023. So if you need a do-it-yourself employee handbook template, we have one for sale on the CEA store. You can also give us a call at the hotline if you'd like us to do a customized one for you. We can give you your options on that too. But I strongly encourage you, put it on your end of the year to-do list to create that new employee handbook for 2023, where you clearly list what policies apply to all of your employees, including leaves of absence. Now, when it comes to what you as an employer can require, you can require paid sick leave. Again, that should be above and beyond a paid sick leave benefit, above and beyond what the state of California requires. And you can't require that when an employee is receiving state disability insurance. You can require the use of vacation or paid time off if it doesn't include the state paid sick leave. But again, you can't require it if the employee is receiving state disability or paid family leave. But very often an employee will ask to use some of their vacation time or some of their sick time to help supplement those state benefits that they receive. Because remember, they don't receive 100% wage replacement from the state with SDI. It's normally about 60 to 70% depending on their earnings. And then of course, when it comes to CFRA, you've got to make sure you're providing them with all the forms and notifications, make sure you're designating that leave, make sure you notify them if there's missing paperwork or if there's any additional information you need to get from them. Now, a couple of things you are not allowed to do. We never want to ask our employee for diagnostic information. We don't say, so what's going on? What's wrong with you? That is confidential. If the employee wants to share that, they can, but we can never require that they give us that information. When it comes to if somebody is taking time off to care for a family member, you cannot request additional medical opinions. When it comes to caring for a family member, in very limited circumstances, you can if it's the employee's own health condition. But again, be cautious with that. Call the hotline or consult with counsel before you do that. We never want to contact the employee's healthcare provider. You can contact them to verify the validity of a note, but you don't want to contact the healthcare provider to say, so what's going on with them? What's their medical issue? First of all, they wouldn't disclose that and they shouldn't disclose that. But you as an employer, again, that's not information that you necessarily need to have. So you don't want to ask that. Also, you can't request medical certification for baby bonding. You could request other documentation, for example, a birth certificate. But again, make sure you're being very consistent in what documentation you are requiring your employees to provide. Don't ask one employee to provide something that you wouldn't ask every other employee to provide. And what paperwork must you provide? Well, there's quite a bit when it comes to CFRA or FEMLA. I'm sure if you're familiar with those, you need to provide the notice of eligibility and rights of responsibility, medical certification form that you can provide to the employee to have their doctor fill out. You always want to make sure you're using the state of California form. Do not use the federal DOL, the Department of Labor form, because it asks for info that you cannot ask in California. So that's why we don't want to use that one. You want to make sure you give that designation of leave. That's when you specify that, yes, you're taking this date from this date. Here's all the paperwork that we've received or any information that you still need. And then, of course, you're also going to provide the SDI, State Disability Insurance, and PFL, Paid Family Leave pamphlets from the state of California. Now, if you're a CEA member, we do have a really nice leave of absence toolkit that is available to you on the website. So make sure you check that out if you need to access that. Now, another thing to keep in mind, if you have 5 or more employees, are something that are known as reasonable accommodations. So FEHA, that's the Fair Employment Housing Act, they say if you have 5 or more employees, you may need to provide a reasonable accommodation, which might include a leave of absence to your employee if they have a physical or mental disability that is preventing them from doing the essential functions of their job. So this is not a black and white kind of leave of absence or reasonable accommodation. Each of these are a case-by-case basis, which means you need to go through what's known as the interactive process to determine what sort of reasonable accommodation you are able to provide to your employee. You might have heard of a term called an undue hardship, and that's when an employer says, I can't provide a reasonable hardship, or a reasonable accommodation because it creates an undue hardship. Be very cautious with this. The burden is always on the employer to show why this created such an undue hardship. They couldn't make this accommodation. This is another good opportunity for you to consult with legal counsel to discuss that before you make that determination. So thinking back to the earlier example we gave about Jane, who was having her knee surgery. So even if she's not qualified for CFRA, we do have to take a look at a reasonable accommodation for her. Maybe we do need to grant her a time off. Maybe she's saying, I just need another week, or I just need another 2 weeks. So that's what you have to determine. Is that a reasonable accommodation that you could provide to that individual under FEHA? So let's go back to Jane. So she took her time off for CFRA for her knee surgery. She's now working at the office and she just told you that she's pregnant. So she gave you a doctor's note saying that she's going to need 4 months off due to her pregnancy-related disability. So what is required? Let's transition over to talk about pregnancy disability leave. Again, this applies if you have 5 or more employees in the current year or in the prior year for 20 or more weeks. So if you have a fluctuating headcount, make sure you take a look and find out, do you have 5 or more employees for 20 or more weeks? Now, who's a covered employee? This is any time that a healthcare provider says that the employee can't perform the essential functions of their job and need to take some time off. And what can this be used for? Well, this can be used before the due date. Maybe this is for bed rest if somebody needs to take some time off due to a high-risk pregnancy. Maybe it's due to severe morning sickness. Maybe there's hypertension going on. Or this can also be used for the loss or end of a pregnancy, or after the person gives birth. Normally it is 6 to 8 weeks of recovery, but maybe they have some extenuating circumstances. Maybe there's postpartum depression. Maybe the doctor thinks they need a little more time off. So that's when pregnancy disability leave can come into play. When it comes to how much time an individual can take off, this is a little higher than CFRA. An employee can take up to 4 months, which is the equivalent of 88 work days of time off for pregnancy disability leave. Now that time is per pregnancy, not per year. So if an employee took pregnancy disability leave back in January and February, and they just informed you, I'm pregnant and I need to go out in December, that is a separate pregnancy. And so they have a new amount of pregnancy disability leave that they can take. Now, the leave can be used all at once, or again, it can be used intermittently. So maybe somebody needs 2 weeks off in the first trimester because they need some bed rest, and then they are able to come back to work for a couple of months, and then they need 2 weeks off before their due date and 6 to 8 weeks after. So it can be broken up. Now, the employee can use their paid sick leave. Again, it's their choice if they want to use the California paid sick leave. If you provide a benefit higher than the California paid sick leave, then you can require the employee to use that. Again, unless they're on state disability insurance, then you cannot. Now, the employer cannot require the employee to use vacation or a paid time off plan. But again, employees often do request to use some of that time to supplement wages from the state. And that time that's needed, that needs to be certified by a healthcare provider. So that means you ask your employee to provide you with a note saying that they need this time to this time off to care for themselves, or if it's used after they give birth to recover from the pregnancy. When it comes to time off beyond pregnancy disability leave, this is very often where CFRA comes into play. So you might remember earlier I told you that CFRA cannot be used for pregnancy. That's because the state of California doesn't consider pregnancy a disability for purposes of CFRA because we already have pregnancy disability leave. So employees that are taking pregnancy disability leave can then often take 12 weeks of CFRA for baby bonding. Now for Jane, she already used her CFRA earlier in the year for her knee surgery. So she's probably not going to have any of that baby bonding time that's available. But in a few months or 6 months or 9 months, she might be eligible for CFRA again. And at that point, she might be able to take some CFRA for baby bonding. And again, as I mentioned before, we have the FEHA, which is the Fair Employment Housing Act. And there's also the ADA, Americans with Disability Act, which applies if you have 15 or more employees. That is that, again, reasonable accommodation. Maybe somebody needs some more time off to recover from their pregnancy. You might need to take a look at giving them a reasonable accommodation if they don't qualify for CFRA. So as you can see, there's a lot of different laws that can come into play when dealing with these employee issues. So let's talk about the employee requirements when it comes to PDL. So again, the employee should give 30 days advance notice if they can. Again, they need to provide written medical certification within 15 days of you requesting it. You as an employer are going to now provide the pregnancy disability leave documents. So there is a poster that goes along with that. There's also your policy, so you can provide them a copy of that. Again, there's that medical certification form. Again, remember, we're going to use the state of California's form for that. We're going to give them a copy of the lactation accommodation policy, as well as the state disability insurance. Now, again, when it comes back to reinstatement, that employee needs to be reinstated to the same or virtually identical position, unless that position would have been eliminated regardless of their status. So for example, somebody is out on the leave of absence and you have to do a reduction in force and an entire department is laid off. And that employee was part of that department. They just weren't there because they were on a leave of absence for pregnancy disability leave, for example. And that position just simply doesn't exist anymore. So in that situation, you wouldn't necessarily be able to return that person to the position because it simply doesn't exist. But again, anytime somebody is out on a leave of absence, it's always good. Give us a call on the hotline or consult with counsel before, again, you do any sort of termination. Couple of things to remember. Pregnancy disability leave is also unpaid. The employee can choose to use their vacation. They can choose to use paid sick leave or PTO. But again, be careful with what you're requiring based on what benefits they might be receiving from the state. And again, we only require an employee to use paid sick leave above and beyond what the state requires us to provide. And you always continue your employees' health insurance when they are out on a protected leave. So if it's CFRA, if it's PDL, or if it's FEMLA, which we're going to talk about in just a minute, we always maintain our employees' benefits when they're out on that protected leave. So that means you as an employer pay the portion that you always pay, and the employee is responsible for paying their portion as well. So you might be asking, well, what do I do if an employee isn't receiving any wages? They're not taking any vacation pay, it's just unpaid. So this is why you want to make sure you sit down with your employee before that leave begins and you have a discussion with them about any paperwork that you might need from them. This is where you can provide them with their rights and responsibility designation notice, but this is also where you remind them that you're on our health plan. Every month you pay $250 a month. We need you to continue paying those benefits. You can write us a personal check. You can create an invoice for them that you give to them and ask them to send it in by the 10th or the 15th of the month, whatever's appropriate for your workplace. But do make sure you let the employee know that they do need to continue to pay those benefits. Now, again, as I mentioned before, we've got the change to CFRA. You want to make sure that you make all of those changes in your employee handbook. There were big changes in 2022. There are other big changes in 2023. So make sure you're staying up to date all of those. So let me give you another leave calculation since we've talked about CFRA and now we've talked about pregnancy disability leave or PDL. So you have your employee Peyton who works at your charming coffee shop that you have. And this individual has been employed for over a year. They've completed 1,250 hours of service in the past 12 months, and your coffee shop has 5 or more employees. The manager designates the time off as pregnancy disability leave. Following PDL, Peyton requests baby bonding time. So how much time can this individual take? Well, here it is right here on the chalkboard. So an individual can take 4 months for pregnancy disability leave. Then they can take 12 weeks of CFRA for baby bonding. So you might have an employee who can take up to 7 months of unpaid job protected leave. And during that time, benefits continue. So that means, again, you are paying your portion of the benefits. The employee is required to pay their portion of the benefits. So I know that's a very long time for someone to be off for a small business, but this is, again, why you want to make sure you're staying up to date on what leaves apply to you so that you can make sure you are managing them correctly and consistently. You're giving everybody the time off that they are entitled to, but the employee is also doing their part into providing documentation, staying in touch with you, letting you know how much time they need to take off so you can plan accordingly. So let's talk about a new leave that is coming up for 2023. So again, this doesn't go in effect until January 1st of 2023, but California now has bereavement leave. But this is, again, it's unpaid bereavement leave, but this entitles employees up to 5 days of unpaid bereavement leave. In order to be eligible, they need to have worked for you for 30 days before the leave began, and they need to utilize that leave within 3 months of the day of the person's passing that they are taking time off for. Now, they don't need to use this time consistently, and this often happens. An employee might say, I need to take off Wednesday and Thursday to deal with making funeral arrangements, and then the funeral is going to be in 2 weeks, and I'm going to take off Friday and Monday, whatever it is. So those days can be taken intermittently. You can request appropriate documentation. That could be an obituary, a death certificate. Again, be consistent in that and make sure you're requesting that documentation of every employee who takes time off for that. This is, again, a reason that you'll need to update your handbook for 2023, because you're going to need to make sure you put some forms together and have new language in your handbook about this time off benefit. Now, as I mentioned before, this is unpaid, but many of you might already have a bereavement leave plan where perhaps you provide 2 days of paid bereavement leave. So you can use this in conjunction with your own benefit, but keep in mind, this is where you're going to want to do a policy update to be very clear about what days are paid and what days are unpaid. And of course, when it comes to bereavement, make sure you're always maintaining confidentiality, or we don't want to disclose anytime an employee is taking time off, the reason they are taking time off. That's not your job as an employer. If the employee wants to tell people, that's fine. If the employee tells you as the employer, it's okay if you tell people that I'm taking time off for this reason, that's fine, but just don't automatically disclose that information because again, that is confidential. When it comes to covered family members, that is spouse, registered domestic partner, child, parent, parent-in-law, sibling, grandparent, and grandchild. So that is the new bereavement leave. Again, that goes into effect January 1st of 2023. Couple of additional leaves just to give you a little highlight of some of these. If you have 15 or more employees, organ and bone marrow donation, that is actually a paid leave that we have in the state of California. If you have 16 or more employees, there's Civil Air Patrol, where if people are part of the Civil Air Patrol, they are the great people that go in when there is a natural disaster and they fly in to either drop off supplies or if they're looking for people, they can get up to 10 days off. That is an unpaid leave. 25 or more employees, there's protection for drug and alcohol rehab, as well as school activities leave and military spousal leave. If you have 26 or more employees, we do have California supplemental paid sick leave. I've got a slide on that I'm going to show you in just a moment. That is set to expire December 31st of this year. And then if you have 50 or more employees, then there is the Federal Family Medical Leave Act. So a lot of different leaves. As you can see, the larger you become as an employer, the more leaves that you've got to take a look at and provide for your employees. So let's talk about supplemental paid sick leave for a minute here. So this applies if you have 26 or more employees. You've probably heard about this. There's been a lot of confusion because even though it was in effect from January 1st, it wasn't actually signed until March, and then it was retroed back to January 1st. It was originally set to expire September 30th, and then it got extended to December 31st. So if you are confused by this law, don't worry, you are not alone. It's a very confusing law. But here's what this can provide to your employees. This gives your employees up to 2 buckets, 40-hour buckets of paid time off that they can take. So there's 2 reasons. Bucket number 1 is if they are taking time off because they are experiencing symptoms of COVID, they are caring for a family member who is experiencing symptoms of COVID, or they are taking time off to recover if they had a vaccine and had a reaction to that and needed to take a couple of days off. That is the first 40-hour bucket. And then there is another 40-hour bucket that is specifically to be used when an employee tests positive for COVID or when they're caring for a family member that tests positive. So it is a total of 80 hours. Now, there are not a direct tax credit. You might remember from last year, if you remember the FFCRA, where there was a direct tax credit that you could take. There is a new provision that you might be able to get some of the funds back if you do provide your employees with supplemental paid sick leave. That's through the state of California. So you can take a look at that. We have more information on our website. But keep in mind when SPSL, I mentioned earlier, exclusion pay. When an employee is out for exclusion pay when they're quarantining, waiting to find out if they have tested positive, you cannot use supplemental paid sick leave at that time. Once an employee tests positive, then supplemental paid sick leave could be used, but exclusion pay is really kind of a standalone benefit for that. The other thing to keep in mind with supplemental paid sick leave is you need to show the amount that is used on an individual's pay stubs. Now, you might know with regular paid sick leave, you just need to show the amount that's accrued. But when it comes to supplemental paid sick leave, you have to show the amount that has actually been used. So this is something to keep in mind for the end of the year too, as we start to wrap up our year here. After December 31st, if supplemental paid sick leave does indeed expire, which we expect it to, make sure in January that you remove that supplemental paid sick leave line item from your paychecks, since that benefit will not be available to your employees anymore. All right, let's spend just a couple of minutes talking about FMLA for our larger employers. So if you have 50 or more employees on the payroll, excuse me, for 20 or more work weeks in the current or preceding year, you are a FEMLA covered employer, which means you need to post your FEMLA poster. And this is again where you need to find out if the employee is eligible for FEMLA, and I'll show you what that means in just a moment. Slightly different eligibility requirements and covered reasons than CFRA, so that's why you've got to make sure that you're paying attention to these leaves. And also, if you have both of these leaves in your handbook, make sure that they are separate leaves. So CFRA should be a separate leave from FEMLA. A couple of years ago, you were really able to combine them because the leaves were very similar. But now that they have been broken out and there are different provisions for each law, you want to make sure that you have a separate CFRA leave policy and a separate FEMLA leave policy. So let's take a look at what it means to be an eligible employee. So in order to be eligible, you have to work at the employer or for the employer for 12 months. In the previous 12 months, you have to work 1,250 hours. But here's the real big difference between FEMLA and CFRA. There is this work location requirement. So you have to work at a location that has 50 or more employees within a 75-mile radius. So if you have a location in, let's say Visalia, for example, where you have 30 employees, and then you have a Sacramento location where you have 80 employees, if that is more than 75 miles, your Visalia employees would not be eligible because they don't work at a location that has 50 or more employees within a 75-mile radius. So we always want to take a look at eligibility. When it comes to why people can take FEMLA, a lot of reasons. Birth of a child, adoption, or foster care. So this is one of those situations where if you're a larger employer, you can actually run FEMLA and PDL concurrently because FEMLA sees birth of a child as a covered reason under FEMLA. Or excuse me, I'm sorry, that's going to fall under pregnancy, under the employee's own serious health condition. So pregnancy, but again, it can run, PDL can run concurrently with FEMLA. This can run concurrently with workers' comp, or again, to care for a family member with a serious health condition. But FEMLA has different definitions of covered family members than CFRA. So I'm going to show you an example of how that can come into play, how people might be able to use both leaves. And again, there's time off for a military caregiver when they have a qualifying leave for that. Now, what do employees get with FEMLA? They get 12 weeks of unpaid leave in a 12-month period. There's actually 26 weeks for a military caregiver they can take under FEMLA. The job protection and right to their job to be reinstated to a virtually identical position. So that's very similar. We also, again, continue their health benefits at the same level they were at before the employee went out on leave. They can also apply for state disability insurance or paid family leave from the state. And again, intermittent leave might come into play based on what the medical provider, what their caregiver says that they need to take. So let me give you an example here of how these laws can actually be even more confusing, but how they can be taken separately. So you have a full-time employee. The employer has 50 or more employees. They've worked for a year for you, and they've worked enough hours. They've worked over 1,250 hours. They need to take time to care for a grandparent. So a grandparent is not covered by FEMLA, but it's covered by CFRA. So the employee takes 12 weeks of CFRA to care for a family member. Then that employee comes back to work, but then experiences their own health condition. Maybe they have a knee surgery that they need to take. The employee then takes 12 weeks of FEMLA because FEMLA leave has not been used yet. So you might end up with a situation where an employee has 12 weeks for CFRA and then has 12 weeks for a FEMLA qualifying leave. So again, this is why we've got to take a look at each of these leaves and determine what the employee is really qualified for. But remember, for every protected leave, those benefits are going to continue. It is an unpaid leave, but their job is protected. So let's talk about how you need to calculate this 12 months that I keep talking about. So you as an employer get to determine what a 12-month leave is, what that means. So you can either use the calendar year, you can use any other fixed 12-month year. So perhaps you use the fiscal year of July through June. You can use the employee's anniversary or hire date as that year. You can use a 12-month period measured forward from the first day of leave. But as you can see on the slide, we have highlighted for you in green, a 12-month period measured backward from the first day of leave. This is usually the most advantageous way for the employer to calculate that 12-month cycle. So what that means is you would, if you have an employee who requests leave as of November 15th, excuse me, you would take a look at November 16th of 2021 through November 15th of 2022 and determine how much time off for FEMLA or CFRA they have used in the previous 12 months, and that would help you determine how much time they have going forward. Keep in mind, you want to pick one method and it applies to all your employees, and you want to make sure you specify what that 12-month cycle is that you're using in your handbook policy. When it comes to those FEMLA requirements, very close to CFRA. So your employer obligations are the same that we discussed, the employee obligations are the same, and the paperwork is all the same. So you give them the rights and responsibilities, you give them the designation notice. Again, you're going to make sure you're using those California compliant forms. And again, remember, we've got that leave of absence toolkit if you're a CEA member that you can access that really does take you step by step through all of these leaves that we've chatted about. So let's talk about a couple of other optional leave policies. And you might be thinking, wait, I thought vacation was required in California. It is not required in California. So you are able to offer these if you would like to, but again, it is at the employer's discretion. So vacation time, completely up to you. If you want to offer vacation time, if you want to offer paid holidays, that is your discretion. There are not any certain holidays that are required to be paid or required to be granted off. Again, that is completely up to you. You can also grant employees a personal leave of absence. Sometimes employers like to grant an employee, they'll say, you know, we can grant you up to 30 days of an unpaid personal leave. And maybe that's if somebody needs to take care of a family member and they're not covered by CFRA or FEMLA, or maybe they need to go out of country for a family reason. So that can be a personal leave of absence for that. You also might have a bereavement leave policy. Again, you might have had one in place for the past couple of years, but we have the new California 5 days unpaid bereavement that we talked about. But maybe you offer something above and beyond that. Maybe you offer some paid time or you offer an additional benefit. So again, that's all at your discretion. You do, of course, have to provide the 5 days of unpaid from the state. But if you want to provide something above and beyond that, you're able to do that. But keep in mind, once you provide some of these policies, there are specific rules that apply. So when it comes to vacation time, vacation is seen as an accrued wage in the eyes of the state of California, which means wages need to be paid out upon termination. So if you grant your employees a vacation benefit and you say you accrue a week or 40 hours of vacation each year, and an employee leaves, when they leave, you need to pay them out all of that accrued time. You can't have a use it or lose it vacation policy in California. You have to make sure you're always paying that out upon termination. So something to keep in mind. Again, give the hotline a call anytime you have questions on those. So we do have a lot of great cheat sheets for you out on our website. We've got labor laws and the employers affected, which really shows you based on your head count, which laws you need to follow and make sure you're granting leaves to your employees. Again, you've got the hotline. I'm going to show you those numbers here again in just a moment. You can always give us a call. And if you are thinking, gosh, I really do need a new handbook, but I can't do it. We help so many people put together customized handbooks. We're happy to help you with that as well. Give us a call. And if you're not a CEA member, we'll put you in touch with our services team and they can let you know what your options are there. One option is getting your own CEA membership if you think that's something that might help you. We've got a couple of different levels. We have a monthly membership. So again, you can visit our website or give us a call if you have any questions on that. And then I'm going to bring up first, before I bring you that evaluation slide, these are the HRCI and the SHRM codes. So you certainly deserve credit for being here today. So let's give you the HRCI code. That's 606285. That SHRM code is 22-QHHPT. And I'm sure every HR person just thought HPT and thought of harassment prevention training. So I will remind you, if you have not done harassment prevention training, remember it's a 2-year cycle. So make sure every 2 years, your employees are either getting 1 hour for non-managers or 2 hours for your supervisors and management of harassment prevention training. Also, that training needs to be taken within 6 months of hire or within 6 months of promotion to a management position. So do make sure, we've been doing a lot of HPT to get them done before the end of 2022. So make sure you're having your employees stay up to date on that training. So let me bring up those numbers again, and then I'll go back to our survey slide. But here are all of the numbers for the different hotlines. So again, make sure you're calling the county hotline number that you belong to, and that's how they'll pick up the phone, and then they will put you in touch with one of the HR advisors. And again, we're always happy to help you out with that. So let me go back to our survey slide. We would love to hear what you thought about today's presentation. So you can just use your phone and snap that fancy QR code with your camera, and that'll take you, it's a super quick survey. It'll take you just about 30 seconds. But we would love to get any feedback on today's training or any other training that you would like to see. And I think we're all caught up with questions, but Jessica, let us know if there's something we should chat about.
A consistent theme, just for clarification, is when somebody goes on leave, whether you can mandate that they use their vacation or PTO. And just be clear in your policy when you're going to require the use of vacation PTO, and use caution that when somebody is on pregnancy, disability leave, or PDL, you cannot require somebody to use vacation or PTO. In addition, if you combine your mandatory paid sick leave that Mary talked about into a PTO program, you can never require the use of that mandatory PSL. So if PSL and vacation are all in one bucket, you can never require the use of that. So those are the main themes. I answered all of them, but those are some consistent themes. So
great. Yeah, and that's a good reminder too, as everyone's taking a look at maybe updating your handbook and kind of reviewing your policies. If you do have everything combined into a PTO, we really do advise you have separate policies. You've got your vacation bucket and you've got your paid sick leave bucket. Just as the state continues to make more changes, especially adding this designated person, it's getting even more complicated to manage some of those time off programs. So we do always advise best practices to keep them separate, because as you can see, different leaves require or allow you to do different things. So it's a little cleaner if you keep those separate.
for sure.
All right, and with that, I will turn it back to you, Steph. Thanks, everybody.
Thank you so much, Mary and Jessica. And thank you everybody for joining us this afternoon and for all your engagement and all your questions. We hope you learned a lot about leave laws. And as Mary and Jessica touched on, you've got your hotline numbers. If you have any additional questions, please give us a call. We'd be happy to walk you through those. Please fill out our survey. It'll just take you a quick minute, and we love getting feedback to see how we can always improve our events later. And please enjoy the rest of your day. Thank you, everybody.